Public international law concerns the structure and conduct of sovereign states, analogous entities, such as the Holy See, and intergovernmental organizations. To a lesser degree, international law also may affect multinational corporations and individuals, an impact increasingly evolving beyond domestic legal interpretation and enforcement. Public international law has increased in use and importance vastly over the 20th century, due to the increase in global trade, environmental deterioration on a worldwide scale, awareness of human rights violations, rapid and vast increases in international transportation, and a boom in global communications. The field of study combines two main branches: the law of nations and international agreements and conventions. The Italian jurist Sir Alberico Gentili was the first to write on public international law. It is usually distinguished from private international law, which concerns the resolution of conflict of laws. In its most general sense, international law consists of rules and principles of general application dealing with the conduct of states and of intergovernmental organizations, and with the relations inter se, as well as with some of the relations with persons, whether natural or juridical. History. Beginning with the Peace of Westphalia in 1648, the 17th, 18th and 19th centuries saw the growth of the concept of the sovereign nation-state, which consisted of a nation controlled by a centralized system of government. The concept of nationalism became increasingly important as people began to see themselves as citizens of a particular nation with a distinct national identity. Until the mid-19th century, relations between nation-states were dictated by treaty agreements to behave in a certain way towards another state, unenforceable except by force, and not binding except as matters of honor and faithfulness. But treaties alone became increasingly toothless, and wars became increasingly destructive, most markedly towards civilians. Uncivilized peoples decried the horrors, leading to calls for regulation of the acts of states, especially in times of war. Perhaps the first instrument of modern public international law was the Lieber Code, passed in 1863 by the Congress of the United States, to govern the conduct of U.S. forces during the United States Civil War, and considered to be the first written recitation of the rules and articles of war, adhered to by all civilized nations, the precursor of public international law. Part of the code follows military necessity, as understood by modern civilized nations, consists in the necessity of those measures which are indispensable for securing the ends of the war, and which are lawful according to the modern law and usages of war. Military necessity admits of all direct destruction of life or limb of armed enemies, and of other persons whose destruction is incidentally unavoidable in the armed contests of the war. It allows of the capturing of every armed enemy, and every enemy of importance to the hostile government, or of peculiar danger to the captor. It allows of all destruction of property, and obstruction of the ways and channels of traffic, travel, or communication, and of all withholding of sustenance or means of life from the enemy, of the appropriation of whatever an enemy's country affords necessarily for the subsistence and safety of the army, and of such deception as does not involve the breaking of good faith either positively pledged regarding agreements entered into during the war, or supposed by the modern law of war to exist. Men who take up arms against one another in public war do not cease on this account to be moral beings, responsible to one another and to God. Military necessity does not admit of cruelty, that is, the infliction of suffering for the sake of suffering or for revenge, nor of maiming or wounding except in fight, nor of torture to extort confessions. It does not admit of the use of poison in any way, nor of of the wanton devastation of a district. It admits of deception, but disclaims acts of perfidy, and, in general, military necessity does not include any act of hostility which makes the return to peace unnecessarily difficult. Quote, "This first statement of the previously uncodified rules and articles of war led to the first prosecution for war crimes in the case of United States prisoners of war held in cruel and depraved conditions at Andersonville, Georgia, in which the Confederate commandant of that camp was tried and hanged, the only Confederate soldier to be punished by death in the aftermath of the entire Civil War. In the years that followed, other states subscribed to limitations of their conduct, and numerous other treaties and bodies were created to regulate the conduct of states towards one another in terms of these treaties, including, but not limited to, the Permanent Court of Arbitration in 1899, The Hague and Geneva Conventions, the first of which was passed in 1864, the International Court of Justice in 1921, the Genocide Convention, and the International Criminal Court in the late 1990s. Because international law is a relatively new area of law, its development and propriety in applicable areas are often subject to dispute. International relations. Under Article 38 of the Statute of the International Court of Justice, public international law has three principal sources: international treaties, custom, and general principles of law. In addition, judicial decisions and teachings may be applied as subsidiary means for the determination of rules of law. International treaty law comprises obligations states expressly and voluntarily accept between themselves in treaties. Customary international law is derived from the consistent practice of states accompanied by opinio juris, i.e., the conviction of states that the consistent practice is required by a legal obligation. Judgments of international tribunals as well as scholarly works have traditionally been looked to as persuasive sources for custom in addition to direct evidence of state behavior. Attempts to codify customary international law picked up momentum after the Second World War with the formation of the International Law Commission, under the aegis of the United Nations. Codified customary law is made the binding interpretation of the underlying custom by agreement through treaty. For states not party to such treaties, the work of the ILC may still be accepted as custom applying to those states. General principles of law are those commonly recognized by the major legal systems of the world. Certain norms of international law achieve the binding force of peremptory norms as to include all states with no permissible derogations. Colombia v. Peru ICJ 6, recognizing custom as a source of international law, but a practice of giving asylum was not part of it. Belgium v. Spain ICJ 1, only the state where a corporation is incorporated has standing to bring an action for damages for economic loss. Treaties, where there are disputes about the exact meaning and application of national laws, it is the responsibility of the courts to decide what the law means. In international law, interpretation is within the domain of the protagonists, but may also be conferred on judicial bodies such as the International Court of Justice, by the terms of the treaties or by consent of the parties. It is generally the responsibility of states to interpret the law for themselves, but the processes of diplomacy and availability of supranational judicial organs operate routinely to provide assistance to that end. Insofar as treaties are concerned, the Vienna Convention on the Law of Treaties writes on the topic of interpretation that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in the context and in the light of its object and purpose. This is actually a compromise between three different theories of interpretation: the textual approach, a restrictive interpretation, which bases itself on the ordinary meaning of the text. That approach assigns considerable weight to the actual text. The subjective approach, which takes into consideration the idea behind the treaty, treaties in their context, and what the writers intended when they wrote the text. A third approach, which bases itself on interpretation in the light of its object and purpose, i.e., the interpretation that best suits the goal of the treaty, also called effective interpretation. These are general rules of interpretation. Specific rules might exist in specific areas of international law. Greece v. United Kingdom ICJ 1. ICJ had no jurisdiction to hear a dispute between the UK government and a private Greek businessman under the terms of a treaty. United Kingdom v. Iran ICJ 2. The ICJ did not have jurisdiction for a dispute over the Anglo-Iranian Oil Co. being nationalized. Oil platforms case ICJ 4 rejected dispute over damage to ships which hit a mine. Statehood and responsibility. Public international law establishes the framework and the criteria for identifying states as the principal actors in the international legal system. As the existence of a state presupposes control and jurisdiction over territory, international law deals with the acquisition of territory, state immunity, and the legal responsibility of states in their conduct with each other. International law is similarly concerned with the treatment of individuals within state boundaries. There is thus a comprehensive regime dealing with group rights, the treatment of aliens, the rights of refugees, international crimes, nationality problems, and human rights generally. It further includes the important functions of the maintenance of international peace and security, arms control, the pacific settlement of disputes, and the regulation of the use of force in international relations. Even when the law is not able to stop the outbreak of war, it has developed principles to govern the conduct of hostilities and the treatment of prisoners. International law is also used to govern issues relating to the global environment, the global commons such as international waters and outer space, global communications, and world trade. In theory, all states are sovereign and equal. As a result of the notion of sovereignty, the value and authority of international law is dependent upon the voluntary participation of states in its formulation, observance, and enforcement. Although there may be exceptions, it is thought by many international academics that most states enter into legal commitments with other states out of enlightened self-interest, rather than adherence to a body of law that is higher than their own. As D.W. Grieg notes, international law cannot exist in isolation from the political factors operating in the sphere of international relations. Traditionally, sovereign states and the Holy See were the sole subjects of international law. With the proliferation of international organizations over the last century, they have in some cases been recognized as relevant parties as well. Recent interpretations of international human rights law, international humanitarian law, and international trade law Chapter 11 actions have been inclusive of corporations, and even of certain individuals. The conflict between international law and national sovereignty is subject to vigorous debate and dispute in academia, diplomacy, and politics. Certainly, there is a growing trend toward judging a state's domestic actions in the light of international law and standards. Numerous people now view the nation-state as the primary unit of international affairs, and believe that only states may choose to voluntarily enter into commitments under international law. and that they have the right to follow their own counsel when it comes to interpretation of the commitments. Certain scholars and political leaders feel that these modern developments endanger nation-states by taking power away from state governments and ceding it to international bodies such as the UN and the World Bank. Argue that international law has evolved to a point where it exists separately from the mere consent of states, and discern a legislative and judicial process to international law that parallels such processes within domestic law. This especially occurs when states violate or deviate from the expected standards of conduct adhered to by all civilized nations. A number of states place emphasis on the principle of territorial sovereignty, thus seeing states as having free rein over their internal affairs. Other states oppose this view. One group of opponents of this point of view, including many European nations, maintain that all civilized nations have certain norms of conduct expected of them, including the prohibition of genocide, slavery and the slave trade, wars of aggression, torture, and piracy, and that violation of these universal norms represents a crime, not only against the individual victims but against humanity as a whole. States and individuals who subscribe to this view opine that, in the case of the individual responsible for violation of international law, he is become, like the pirate and the slave trader before him, hostus humani generis, an enemy of all mankind, and thus subject to prosecution in a fair trial before any fundamentally just tribunal, through the exercise of universal jurisdiction. Though the European democracies tend to support broad, universalistic interpretations of international law, many other democracies have differing views on international law. Several democracies, including India, Israel, and the United States, take a flexible, eclectic approach, recognizing aspects of public international law such as territorial rights as universal, regarding other aspects as arising from treaty or custom, and viewing certain aspects as not being subjects of public international law at all. Democracies in the developing world, due to their past colonial histories, often insist on non-interference in their internal affairs, particularly regarding human rights standards of the peculiar institutions, but often strongly support international law at the bilateral and multilateral levels, such as in the United Nations, and especially regarding the use of force, disarmament obligations, and the terms of the UN Charter. Case concerning United States diplomatic and consular staff in Tehran. ICJ 1. Democratic Republic of the Congo v. Belgium. ICJ 1. Territory and the Sea territorial dispute. Libya v. Chad. ICJ 1. United Kingdom v. Norway. ICJ 3. The fisheries case, concerning the limits of Norway's jurisdiction over neighboring waters. Peru v. Chile dispute over international waters. Bakassi case. ICJ 2. Between Nigeria and Cameroon. Burkina Faso-Niger frontier dispute case. United Nations Convention on the Law of the Sea. Corfu Channel case. ICJ 1. UK sues Albania for damage to ships in international waters. First ICJ decision. France v. United Kingdom. ICJ 3. Germany v. Denmark and the Netherlands. ICJ 1. Successful claim for a greater share of the North Sea continental shelf by Germany. The ICJ held that the matter ought to be settled, not according to strict legal rules, but through applying equitable principles. Case concerning maritime delimitation in the Black Sea. ICJ 3. International organizations. United Nations, World Trade Organization, International Labour Organization, NATO, European Union, G7 and G20. Social and economic policy. Netherlands v Sweden ICJ 8. Sweden had jurisdiction over its guardianship policy, meaning that its laws overrode a conflicting guardianship order of the Netherlands. Liechtenstein v Guatemala ICJ 1. The recognition of Mr. Notteboom's nationality, connected to diplomatic protection. Italy v France, United Kingdom and United States ICJ 2. Human Rights Universal Declaration of Human Rights. Croatia-Serbia genocide case, ongoing claims over genocide. Bosnia and Herzegovina v Serbia and Montenegro ICJ 2. Case concerning Barcelona Traction, Light and Power Company, Limited ICJ 1. Labor law. International Labour Organization. ILO Conventions. Declaration of Philadelphia of 1944. Declaration on Fundamental Principles and Rights at Work of 1998. United Nations Convention on the Protection of the Rights of All Migrant Workers and Members of the Families. The Convention on the Elimination of All Forms of Racial Discrimination 1965. Convention on the Elimination of All Forms of Discrimination Against Women 1981. The Convention on the Rights of Persons with Disabilities 2008. Development and Finance Bretton Woods Conference. World Bank. International Monetary Fund. Environmental Law. Kyoto Protocol. Trade. World Trade Organization. Conflict and Force. War and Armed Conflict. Nicaragua v. United States ICJ 1. International Court of Justice Advisory Opinion on the legality of the threat or use of nuclear weapons. Humanitarian law. First Geneva Convention of 1949. Amelioration of the condition of the wounded and sick in armed forces in the field. Second Geneva Convention of 1949. Amelioration of the condition of wounded, sick and shipwrecked members of armed forces at sea. Third Geneva Convention of 1949. Treatment of prisoners of war, adopted in 1929, following from the Hague Conventions of 1899 and 1907. Fourth Geneva Convention of 1949. Protection of civilian persons in time of war.